The congressional hearing room felt like a pressure cooker, ready to explode. The air was thick with anticipation, the kind that settles in when two political heavyweights are about to clash in front of a national audience. Governor Greg Abbott sat at the witness table, projecting the confident air of a man who had spent decades navigating the rough-and-tumble world of Texas politics, and genuinely believed he had seen it all. His wheelchair was positioned strategically at the center of the long table, ensuring every camera in the room captured his every gesture, every expression. He leaned into the microphone with the practiced ease of someone who had testified before Congress more times than most people had hot dinners. Today, he was here to pitch his latest legislative masterpiece, the Community Protection Act, a bill he had been selling across Texas as the ultimate answer to rising crime and community safety concerns. His opening statement had been smooth as polished marble, full of the kind of law and order rhetoric that typically played like a greatest hits album with his bass. "We're simply giving law enforcement the tools they need to keep our communities safe," he declared, his voice carrying that familiar mix of Texas swagger, political gravitas, and just a hint of moral certainty. Several seats down the long committee table, Representative Jasmine Crockett listened with the focused intensity of a trial lawyer who had just spotted fatal holes in opposing counsel's entire argument. At 42, the congresswoman from Dallas had built her reputation on two unshakable pillars: exhaustive, almost obsessive preparation and an absolute unwillingness to let political spin go unchallenged. While other members of the committee nodded politely during Abbott's presentation, occasionally glancing at their phones, whispering to aides, or checking the clock, Representative Crockett sat perfectly still. Her pen moved steadily across her legal pad, not merely taking notes, but building a case line by line, fact by fact. She had spent the last 72 hours doing what she always did before high-stakes hearings, reading every single word of the proposed legislation, sometimes aloud to her staff, cross-referencing it with decades of constitutional law, consulting civil liberties experts, and gathering real-world examples of how similar laws had been weaponized in other states. She knew exactly where the landmines were buried. Governor Abbott had just finished painting a vivid picture of a Texas under siege, skyrocketing crime rates, overwhelmed police departments, neighborhoods living in constant fear. The solution, according to him, was straightforward and common sense. Expand law enforcement authority, create new categories of prohibited conduct, and give prosecutors more tools to protect law-abiding citizens. It all sounded eminently reasonable on the surface, wrapped in a kind of who could possibly object to keeping people safe language that had served politicians well for generations. But Jasmine Crockett had read past the talking points. She had seen what was buried in sections 7 through 12, language so breathtakingly broad that it could transform a peaceful protest into a felony overnight, turn a critical social media post into criminal evidence, and empower police to shut down any gathering they subjectively deemed potentially disruptive before it even began. The committee chairman glanced down at his agenda, cleared his throat, and announced what everyone in the packed room had been waiting for. The chair now recognizes the gentlelady from Texas, Representative Crockett, for 5 minutes of questioning. The room's energy shifted instantly. Journalists in the press gallery sat up straighter. Camera operators adjusted their angles. Even the staffers lining the back wall stopped their quiet conversations. Everyone who had followed Jasmine Crockett's meteoric rise knew two things with certainty: her 5 minutes of questioning rarely stayed within 5 minutes, and they almost never went the way the witness expected. Crockett adjusted her microphone with deliberate calm, locked eyes with Governor Abbott, and began. "Thank you, Mr. Chairman. Governor Abbott, I appreciate you taking the time to come before this committee to discuss your Community Protection Act. Before we dive into the details, I just want to make sure I understand your central argument correctly. You're telling this committee, and by extension the American people, that this bill is necessary to keep Texans safe. Is that accurate?" Abbott nodded, his expression still radiating confidence. "That's exactly right, Congresswoman. Public safety has always been my top priority, and this legislation simply gives our law enforcement officers the resources and authority they need to protect our communities." Crockett nodded slowly, as if weighing his words with great care. "And you've mentioned several times in your testimony that this is about fighting crime, protecting families, and supporting our police officers' goals. I think everyone in this room would agree, are critically important." "Correct," Abbott replied, his smile widening just a fraction. "I'm glad we can find some common ground, Representative." It was a tactical mistake, and Crockett had led him straight into it. "Common ground is always a good place to start," she agreed, her tone still respectful, but now carrying an edge sharp enough to make everyone in the room lean forward imperceptibly. "So let's talk about what this bill actually does, Governor. Not the talking points. Not the press release version. But what is actually written in the legislation you are asking Congress to federally fund and support? She reached for a thick-bound document, clearly the bill itself covered in colored tabs and dense handwritten notes. Section 7 of your Community Protection Act creates a new category of criminal offense called organized disruption. Governor, can you explain to this committee what qualifies as organized disruption under the definition your bill puts into law? Abbott shifted almost imperceptibly in his chair, his media-trained smile still firmly in place. That provision is designed to address situations where groups intentionally disrupt public order, blocking roadways, interfering with lawful commerce, that sort of thing. It's common-sense public safety legislation. Crockett nodded again and flipped to a brightly tabbed page. Let me read the American people the actual language, Governor, because I think they deserve to hear exactly what you're proposing. She began reading in a clear, measured voice. Organized disruption shall be defined as any gathering of 3 or more persons that creates, or has the potential to create, interference with normal activities, traffic flow, business operations, or public services. She looked up from the page and fixed Abbott with a steady gaze. Governor, under this definition, couldn't a group of college students peacefully protesting tuition increases on a public sidewalk be charged with felony organized disruption? Couldn't parents gathering outside a school board meeting to voice concerns about curriculum be arrested on the spot? Couldn't workers legally picketing for better wages and working conditions be prosecuted and jailed? Abbott's smile tightened almost imperceptibly. Congresswoman, those scenarios you're describing are purely hypothetical. They are not hypothetical at all, Governor, Crockett cut in smoothly, refusing to yield the floor. They are exactly the kinds of protected First Amendment activities that happen every single day in Texas and across this country. And your bill turns those constitutionally protected activities into criminal offenses. The room buzzed with murmurs. Several committee members who had been only half listening were now flipping hurriedly through their own copies of the legislation. Abbott tried to redirect. Congresswoman, I think you're misinterpreting the intent of the provision. I'm not interpreting anything, Governor, she interrupted again, her voice gaining strength with every sentence. I'm reading your words. And I'm not finished. She flipped to another tabbed section. Section 9 authorizes law enforcement to disperse any gathering they deem to have disruptive potential before any actual disruption even occurs. Governor, that is textbook prior restraint. The Supreme Court has been crystal clear for more than half a century that the government cannot shut down speech based on what it fears might happen. Abbott leaned forward, trying to regain momentum. Representative, with all due respect, public safety sometimes requires proactive. Public safety does not override the United States Constitution, Crockett fired back instantly. And that is precisely what your bill attempts to do. She was just getting warmed up, and everyone in the room could feel the temperature rising. Let's talk about Section 11, she continued without pause. This section creates criminal penalties for using social media or any electronic communication to coordinate activities that may result in disruption. She turned and looked directly into the nearest C-SPAN camera, speaking now not just to Abbott, but to millions watching at home. Governor, do you understand what you have just criminalized? You have made it a crime for American citizens to use Facebook, Instagram, Twitter, group texts, any modern tool to organize a protest. You have turned the basic instruments of democratic participation into evidence of criminal conspiracy. Abbott's face began to flush. Those provisions include safeguards and intent requirements. Where? Crockett challenged instantly. Show me the safeguards, Governor. Because I have read this bill front to back 3 times and I have had constitutional law professors from the University of Texas, SMU, Baylor, and Texas Southern review it. You know what every single one of them said. This bill would not survive its first constitutional challenge in federal court. They said it is a frontal assault on the First Amendment. And they said it appears designed to do exactly what it would do, silence dissent, and criminalize protest. The murmurs in the room grew louder. Abbott attempted a different tactic, his tone shifting to something faintly patronizing. Representative Crockett, I understand that as someone relatively newer to Congress, these complex issues might seem. Governor Abbott, she cut him off, her voice now sharp as a blade, I'm going to stop you right there. Before I came to Congress, I spent 15 years as a public defender and civil rights attorney. I have defended protesters who were arrested simply for exercising their First Amendment rights. I have sued states and won over unconstitutional anti-protest laws exactly like this one in both state and federal courts. So please do not insult my intelligence, or the intelligence of this committee, by suggesting I don't understand precisely what I'm looking at. The room fell into a stunned silence. Even some of the Republican members looked visibly uncomfortable with how quickly the exchange had turned. Crockett pressed her advantage. Let's talk about the real-world impact of laws like the one you're proposing, Governor, because we don't have to speculate. We have data. After the George Floyd protests in 2020, at least 17 states passed so-called anti-riot laws similar to yours, and we know exactly what happened next. She pulled out a new set of documents. In Oklahoma, grandmothers, literal grandmothers, were arrested for peacefully gathering outside their state capital to oppose education budget cuts. In Florida, environmental activists were charged with felonies for organizing a beach cleanup that included signs about climate change. In Iowa, disability rights advocates were prosecuted for briefly blocking access to a senator's office while protesting Medicaid cuts. In Texas, Governor, a Black Lives Matter organizer, was charged under a similar statute and faced years in prison simply for helping plan a march. With each example, Abbott's expression grew more strained. But here's what really troubles me, Crockett continued, her voice now carrying the weight of a prosecutor delivering closing arguments. Your bill goes even further than those state laws. Section 12 creates civil liability for anyone who provides material support to activities that result in arrests under this act. She paused for effect. Do you know what that means in plain English, Governor? If a church hands out water bottles to protesters on a 100-degree Texas day, that church can be sued. If a local business lets demonstrators use their restroom, that business can be held financially liable. If a lawyer like the lawyer I used to be provides free legal advice to someone arrested under your law, that lawyer can be penalized. She leaned forward, her eyes never leaving Abbott's. Governor, you are not simply criminalizing protest. You are attempting to make it impossible for communities to support one another when they exercise their constitutional rights. That is not public safety legislation. That is authoritarianism dressed up in a Stetson. The word hung in the air like a thunderclap. Camera flashes illuminated the room. Journalists typed furiously. Abbott's face had gone from confident to defensive to visibly angry. Representative Crockett, he said through a tightened jaw, that characterization is completely unfair and inflammatory. Is it? She challenged instantly. Let me ask you a direct question, Governor. Yes or no? She held up a photograph that had been projected onto the hearing room screens. Civil rights marchers crossing the Edmund Pettus Bridge in Selma, Alabama, 1965. Under your Community Protection Act, could the marchers who walk from Selma to Montgomery, peaceful Americans fighting for the most fundamental democratic right of all, the right to vote, could they have been arrested? Abbott recognized the trap immediately. Representative, the historical context is completely different. Answer the question, Governor. Yes or no. Could they have been arrested under your law? The specifics would depend on. Yes or no, Governor. It's a simple question. Would the Selma marchers have been criminals under the Community Protection Act? Abbott's jaw clenched. He tried to pivot again. The intent of that march and the intent of this bill are completely. That is not what I asked, Crockett pressed relentlessly. I asked if they could be arrested, and the answer is yes. Under Section 7, they were more than 3 people interfering with traffic flow. Under Section 9, law enforcement could have dispersed them preemptively for disruptive potential. Under Section 12, the black churches that fed them and the families that gave them shelter could have been sued into bankruptcy. She let the weight of that settle for a long beat. Your bill, Governor, would have made the civil rights movement illegal. The room erupted. Democratic members began applauding. Republicans shouted for order. Journalists shouted follow-up questions. Abbott sat frozen at the witness table, his carefully constructed political narrative lying in tatters. But Crockett wasn't finished. She reached into her folder and held up a pocket-sized copy of the U.S. Constitution, her signature prop in moments like these. Governor Abbott, she said, her voice cutting through the chaos like a bell, the First Amendment does not say Congress shall make no law abridging the freedom of speech unless someone in power thinks that speech is disruptive. It does not say the right of the people peaceably to assemble shall not be infringed unless a governor decides public safety requires it. It says these rights shall not be infringed. Period. Full stop. She pointed at the thick bill sitting in front of Abbott. This legislation abridges those rights on virtually every single page. And you came before this committee trying to sell it as common-sense public safety, hoping nobody would actually read what you wrote. Well, Governor, I read it. My staff read it. Constitutional scholars across Texas read it. And we all reached the same conclusion. This bill is dangerous, it is unconstitutional, and it has no place in a free society. Abbott made one last attempt to regain control. "Representative, if you would just allow me to explain the full context." "The context, Governor," she said, cutting him off one final time, "is that you are asking Congress for federal dollars to fund a state law that criminalizes core constitutional rights. And this committee would be derelict in its duty if we gave you a single dime for that purpose." She turned to the chairman. "Mr. Chairman, I move that we immediately table any consideration of federal support for Texas's Community Protection Act pending a full constitutional review by the Congressional Research Service and the Department of Justice Civil Rights Division." Several Democratic members immediately shouted, "Second." The chairman, clearly caught off guard by the dramatic turn of events, gavels for order and says the motion will be taken under advisement. As the hearing continued with other members' questions, the damage had already been done. Abbott's attempt to present his bill as reasonable, mainstream public safety reform had been systematically dismantled in front of a live national audience. Within minutes, clips of Crockett's questioning were exploding across social media. By the time the hearing adjourned, "Crockett destroys Abbott" was trending #1 nationwide. Legal analysts on every network called it a masterclass in constitutional cross-examination. Former Attorney General Eric Holder tweeted, "Rep. Jasmine Crockett just delivered a clinic in constitutional law and congressional oversight. This is what democratic accountability looks like." The ACLU, the NAACP Legal Defense Fund, and the Brennan Center all released statements praising her line-by-line takedown. Even some conservative legal scholars who had initially expressed tepid support for the bill began walking it back on air. One prominent Federalist Society member told Fox News that evening, "Look, I'll be honest, after hearing Representative Crockett walk through the actual text, I'm deeply concerned about the prior restraint and vagueness problems. Those provisions are constitutionally indefensible." By the next morning, Governor Abbott's office released a terse statement claiming Crockett had mischaracterized the bill and reiterating his commitment to public safety. But the political damage was irreversible. State legislators in Austin who had been ready to fast-track the bill suddenly went silent. National Republicans who had been preparing copycat legislation in their own states quietly shelved those plans. 3 days later, the nonpartisan Congressional Research Service released a preliminary 38-page report concluding that multiple sections of the Community Protection Act raise serious First Amendment concerns and would likely be struck down in their entirety upon judicial review. 2 weeks after that, facing a growing bipartisan chorus of criticism and recognizing that the bill had become radioactive, Governor Abbott issued a carefully worded statement announcing he was revisiting certain provisions in consultation with stakeholders. Political insiders understood exactly what that meant. The bill was dead-killed not by partisan grandstanding, but by relentless constitutional scrutiny and one congresswoman's refusal to let dangerous legislation hide behind the veneer of public safety. For Jasmine Crockett, the Abbott hearing became another defining moment in what was already a meteoric national rise. Yet when she was asked about it at a town hall back in Dallas, she waved off the viral fame. "I didn't go after Governor Abbott personally," she told the packed room. "I went after a bill that would have turned basic constitutional rights into criminal offenses. That's my job, to read the legislation carefully, to understand its real-world impact, and to speak up loudly when something threatens the freedoms that make America, America." A grandmother in the audience, who had once been arrested at a peaceful protest against a polluting chemical plant near her grandchildren's school, stood up with tears in her eyes. "Thank you," she said, her voice cracking. "Thank you for actually reading those bills. Thank you for understanding what they would mean for regular people like us." That moment, captured on a dozen phone cameras and viewed millions of times online, encapsulated why Crockett's questioning had resonated so deeply across the country. She hadn't just scored political points or created another viral clip. She had defended, with precision and moral clarity, the constitutional principles that protect every American's right to speak freely, to assemble peaceably, to petition their government, and to demand better from those in power. And in an era when too many politicians bet that no one will bother to read the fine print, Jasmine Crockett proved once again that someone always will.